Under the heading for orders on petition, serial number 12, the State of Bihar versus Yogendra Chaudhary for the appellant Sri Deepak Kumar Jamuar. Deepak Sahai Jamuar.
May I please, your lords? The present appeal, my lord, has been directed against the judgment dated 22nd of February 16, where under your lordship
2 years, 191 days. What is the reason?
limitation petition states, your lordship.
Read the relevant portion of the reasons to condone the delay.
Para 3 onwards, your lordship.
Para 3.
That after getting knowledge of the order, the file moved from the section officer to joint secretary on 25/17, and as per advice of the finance department to file LPA, the file moved from section officer.
Who has sworn the affidavit? Executive engineer.
Yes, your lords.
Read para 3.
That after getting knowledge of the order, the file moved from the my lord, I will be slow today, my lord, because I am not carrying good health. I will be slow somewhat, my lord, today, your lordship.
Only today. Only today.
Slightly in this court.
Not carrying very good health, that's why.
No, if you are uncomfortable, we'll take up
नहीं,
this
इसको हम
matter.
पढ़ लिया. सेकंड एक और है, उसमें भले हम गुजारिश करेंगे पास ओवर के लिए. इसको हमने पढ़ा है, इसलिए हम करके ही जाएंगे.
Or else we will read ourselves.
नहीं नहीं, हम पढ़ लेंगे.
We will read ourselves.
यस सर, ये वाला नहीं मिला. मुफस्सिल कायदे एस्टेब्लिशमेंट एक्ट.
Yes, sir. We are not happy. We are not happy with the reasoning.
My lord, then I will be referring to, my lord, 1989 AIR, sorry, AIR 1961 Supreme Court list of
Latest
judicial-
Supreme Court you want to see? 2021 and 20. You want to see? Give quote.
My lord, before that, my lord, may I refer to this? Because this law still holds good. AIR 1961 Supreme Court 1704.
AIR.
AIR 1961 Supreme Court 1704. It
Party's
is the
name?
case of
Party's name?
Navratan Mal and others versus the state of Rajasthan. My lord, para 910, my lordship. May I read, your lordship?
Para?
Para 910.
Yes, read.
Para 9 I am reading. This, however, does not militate against there being a rational basis for a distinction being drawn between the claims of the state and the claims of the individual in the matter of provision of a bar of limitation for enforcing them. In considering this matter, 2 points have to be kept separate. Number 1, whether a distinction could be drawn or a classification supported between the provision of any variation in the time that should be available for enforcing claims by private individuals and claims by the estate. 2, whether if such a classification were good, the period of 60 years provided by Article 149 of the Indian Limitation Act is such a long period of time as to be unreasonable. AIR 61 Supreme Court 1704 Navratan Mal and others 1704. I'm sorry, lords. I'm at the cost of repetition again, I will tell you. This, however, does not militate against there being a rational rational basis for a distinction being drawn between the claims of the estate and the claims of the individual in the matter of a provision of a bar of limitation for enforcing them. In considering this matter, 2 points have to be kept separate. Number one, whether a distinction could be drawn or a classification supported between the provisions of any variation in the time that should be available for enforcing claims by private individuals and claims by the estate. Number two, whether such a classification were good, the period of 60 years provided by Article 149 of the Indian Limitation Act is such a long period of time as to be unreasonable. We are drawing attention to the distinction.
That's all.
Lord, kindly see para 9 and 10, your lords.
You are just now read.
I am still to read, my lord.
Read para 10.
Para 9, my lord, remaining part, my lord. If learned counsel is right in his submission that there is no rational basis for placing private individuals and the government in different classes, while framing a legislation provided for limitation for actions, he might succeed. But if he is wrong there and the correct view is that there is a rational basis of classification, then the period that should be allowed to the government to file a suit would be a matter of legislative policy and could not be brought within the scope of review of challenge under Article 14 or indeed of any other article in the Constitution. It is sufficient, therefore, if we confine ourselves to the first point, that is, whether there is a rational basis for treating the government differently as regards the period within which claims might be put in suit between the government on the one hand and the private individual on the other. Para 10, your lordship, it is very important. First and foremost, there is this feature that the Limitation Act, though a statute of repose and intended for quieting titles, and in that sense looks at the problem from the point of view of the defendant with a view to provide for him a security against stale claims, addresses itself at the same time also to the position of the plaintiff. Thus, for instance, where the plaintiff is under a legal disability to institute a suit by reason of his being a minor or being insane or an idiot, it makes provision for the extension of the period taking into account the disability. Similarly, public interest, I would be emphasizing this part. Similarly, public interest in a claim being protected is taken into account by Section 10 of the Act by providing that there shall be no period of limitation in the case of express trust. It is not necessary to go into the details of these provisions, but it is sufficient to state that the approach here is enforceability of claims, which, if the ordinary rules applied, would become barred by limitation. It is in great part of this principle that it is said that subject to a statutory provision, while the maxim vigilanti, a rule for the subject, a maximum nullum tempus occurrit regi is a general applicable to the crown. The reason assigned was, to quote Coke, that the state ought not to suffer for the negligence of the officers or for their fraudulent collusion with the adverse party. It is with this background that the question of a special provisions contained in Article 149 of the Act has to be viewed. First, we have the fact that in the case of government, if a claim becomes barred by limitation, the loss falls on the public, that is on the community in general, and the benefit of the private individual who derives advantage by the lapse of time. This itself would appear to indicate a sufficient ground for differentiating between the claims of an individual and the claims of community at large. Next, it may be mentioned that in the case of a government machinery, it is known fact that it does not move as quickly as in the case of individuals, apart from delay occurring in proper offices. My Lord, why I am referring to this, Your Lordship? with a view to, my lord, emphasize that para 10 of the judgment, my lord, of the Honorable. And this judgment is rendered by your lordship. Kindly see for a moment. Kindly come to page, my lord, 1704, left side top. It is 1, 2, 3, 4, 5. Constitutional bench judgment. And why I am referring to this, your lordship? Here the grievance of the writ petitioner was, my lord, that he was his amendment in the pay scale is illegal. That is the case. And, my lord, if a wrong was committed by some authority which came to be corrected by some other person, my lord, and that led to correction in the pay scale, my lord, it will have a wide impact on the state resources, because somebody is getting illegal, and because of the judgment of this honorable court, everybody who has been the, my lord, the storekeeper, who has been the storekeeper, my lord, and the junior accounts clerk pay scale was not available to him, but wrongly it was granted.
No, it is not a pay scale, it is a promotion.
Hmm?
Matter relates to promotion.
I'm sorry, एक दूसरा केस में था. I'm extremely sorry, your lordship. Yes. Sorry, it is backdate promotion.
No,
Then
backdate-
kindly see, my lord. I'm sorry.
Why he is not entitled to
Yes.
monetary benefits from the date of promotion?
I'm sorry. I'm extremely sorry, my lord, because of the illness ailment. Kindly see, my lord, Bihar financial rules. I'm sorry, your lordship. I mixed the two cases.
पानी पानी अगर पीना है तो आप
नहीं हुजूर, आज पता नहीं, मॉर्निंग में इसी केस को झुक के पढ़ रहे थे तो यहाँ रिब्स में हो गया था, स्पॉन्डिलाइटिस तो है ही, हेडेक हो गया सीरियस. काइंडली सी, my lord. क्या दीपक जी, किसका केस किस में दे देते हैं, ये किसका है? Yes, kindly come to, my lord, Bihar financial rules, my lord.
What is the date of promotion?
अरे बगल तो आइए नहीं यार. My lord, kindly have some dates, your lordship, which are not in the order, my lord. The executive engineer, my lord, appointed the petitioner, my lord, on provisional basis as PN. If your lordship will go by the date, my lord, perhaps that will clarify. May I refer to some dates, your lords? Some dates, your lords. The claim of the petitioner was, my lord, that during the entire service career, my lord, he was not granted promotion. That is not the factual matrix.
No, promotion means is it promotion to any particular post or with reference to ACP or something
ACP,
like
I am referring to ACP.
ACP.
And I'm not on that score, your lordship. Only, my lord, I was trying to demonstrate, my lord, that he has not approached the court with clean hands.
Huh?
Why? The
He
writ
has not approached this court clean hand.
Why I am saying so, your lordship? If your lordship will see, my lord, your lordship has been pleased to put a question to me, my lord, as to on which date such promotion came to be granted. It was granted on 15th of February 2011, and which came to be, my lord, corrected, my lord, on
16th
30th of January.
15
On
15th of February 2011.
Pardon?
15th February 2011.
My lord, what has happened, your lordship? 10 correspondence clerk, including the petitioner, came to be promoted, your lordship, on the post of head clerk, with the condition that all will get the financial benefit will be paid from the date of their joining. And thereafter, my lord, kindly see the another corrigendum came to be issued, my lord, on 30th of January 2013. This was not brought to the notice of this honorable court, which pleading I have made in the writ petition, my lord, as well as in the counter affidavit, which which has not been
30th
considered.
of January 2000.
30th of January 2013, where under it has been said, your lordship, the chief engineer issued corrigendum stating therein, my lord, that in view of Rule 74 of Bihar Financial Rule and the one later has been referred to of the Bihar Finance Department, that the back date promotion cannot be granted. And that for that purpose, my lord, I was referring to, for your lordship's kind perusal, my lord, Rule 74 of the Bihar Finance Rule.
It came on 30th.
Your lordship may recollect why your lordship were sitting single.
This came on 30th of January 2013. The order of promotion was passed to promotion on 2011. How is it possible to process? After 2 years you come out with a letter.
Rule 74 of the Bihar Finance Rules, my lord,
We are not on merits.
merit. Then kindly come to, my lord, para 6 and para 10 of the counter affidavit. कहाँ पे है ये? सब तो मोड़ देते हैं. Lord, I may be allowed to read para 6. At internal page 5, my lord, that it is stated that later on, in the context of letter number 2074 dated 4485 of Finance Department, Bihar, Patna, and Rule 74 of Bihar Financial Act, which clearly mentions that in general, in financial matters, financial benefits should not be given. With retrospective effect, the Chief Engineer, Water Resources Department, Bihar, Patna, issued a corrigendum by letter number 239 dated 30th of January 2013 in relation with letter number 459 dated 15/2/2011, indicating that in lieu of the conditions mentioned in para 4 of letter number 459 dated 15/2011, all financial benefits to all the promoted staffs whose name is in the list will be paid from the date of their joining on their respective post and place, and retired employees will be promoted on principal basis, should be read. This letter, my lord, of the 30th of January 2013 was never challenged, although, my lord, it was within his knowledge. And simply a grievance was raised, my lord, that although he has been promoted and a particular pay scale has been granted and that has been deprived of. Then para 10, your lordship. Internal page 8 of the counter affidavit, para 10, that later on, in context of letter number 2074 dated 4485 of Finance Department, Bihar, Patna, and Rule 74 of Bihar Financial Act, ये rule होगा हजूर, which clearly mentions that in general, in financial matter, financial benefits should not be given with retrospective effect.
That is an excellent.
There be a date of joining, right? No, not only that. No, for the purpose of granting ACP, person of joining does not have a date. He has not been promoted to the post of clerk, so as to go and join.
That means the professor will be retired or 20 days. How can he be granted the license?
No, he will not get it. But impracticality of joining.
And that's why, my lord, then I would be drawing your lordship's kind attention to the impugned judgment, which is under challenge before this court, my lord, as to what kind of consideration has been made By referring to para 6 and 10 of the counter affidavit, I have brought to your lordship's notice, my lord, that these factual matrix were available before this honorable single judge.
You could have filed a review petition.
My lord, if my lord something, my lord, has been left out, and it has come, my lord, discovery of facts have taken place, my lord, later on, your lordship, then your lordship's observation is right. Perfectly right, my lord, I could have. But here, my lord, the case, my lord, it is a case of non-consideration by the honorable single judge, which led to, my lord, the passing of the impugned judgment. And what is the impugned judgment? Kindly see, my lord, it is attached with the memo of appeal, and to what extent, my lord, consideration has been made of the pleading in the counter affidavit. Two facts I would be referring to. My lord, it is a case of non-consideration by the honorable single judge of the factual matrix already available on the record. Number two, and a statutory rule, my lord, has been referred to. Number two, your lordship, that 2013 letter which I have read, your lordship, where under, my lord, corrigendum came to be issued, rectifying the mistake committed earlier, by the letter dated 15th of February 2011. Lord, that was not challenged, and it was to the knowledge of the writ petitioner, my lord. It was not challenged, and it has not been set aside. Still, what relief has been granted? Kindly see, my lord.
Last para.
In
Read
this
last
case,
paragraph.
pardon.
Read last paragraph. Let the petitioner file an application.
My lord, before that, if the honorable single judge has given the finding, my lord, I have to read this last paragraph in view of the finding referred to above. Unless and until I refer that, my lord, I have to say, my lord, that I have to submit rather, that this finding is incorrect, contrary to law.
Still, you had all the opportunity to pass a reasoned order.
Pardon?
Pass a reasoned order incorporating all the facts which you are.
Why? Why? Then why it has been challenged? Exactly right question has been put to me for answer. Then kindly, my lord, from page 1. In this case, petitioner is seeking, it is not that only, my lord, region order is to be passed. No. Once, my lord, finding has been given by a honorable court, your lordship, my lord, no region order contrary to that can be passed.
Word examine is there.
Pardon?
Word examine is there. Let the petitioner file an application.
नहीं नहीं, उसके पहले
You
पढ़ा
will
जाएगा.
examine the case. Examine word is there.
जरा सा उसके पहले हजूर पढ़ करके तब हम, अगर हमको वो होता तो हम पास कर देते ऑर्डर. 2 मिनट नहीं लगता. इन दिस केस द पिटिशनर, चूंकि हमारे एक्सचेकर को बहुत फाइनेंशियली हिट करेगा, जिसके लिए ये लोग इंटाइटल नहीं है. हजूर को हम याद कराएं, हम हजूर के यहाँ जब लॉर्डशिप वाज सिटिंग ऑनरेबल एज सिंगल जज, my lord, this pay scale matter, my lord, had appeared, in which your lordship has been pleased to direct chief engineer to be present. Large number of cases are, my lord, they were, and that's why, my lord, it would be hitting hard on the exchequer of the state, and peoples, my lord, who are not entitled to, my lord, for the particular pay scale would be getting higher pay scale, and that's why, my lord, I am giving due importance to this case.
Respondent retired as what?
My lord, he has retired lordship on
No,
31
retired as
5.
what?
My lord, as head clerk, he was
Retired as a peon or clerk?
head clerk. My lord, he was appointed
Clerk.
initially as PN, my lord,
He retired as a peon or a clerk, sir?
clerk.
Clerk.
Hmm.
What is the date of promotion to the post of clerk? Where is the promotion order?
He was, my lord, on 30th of August 1994 appointed as post of correspondence clerk.
Sir, please let us know where is the promotion order to the post of clerk, because his initial appointment is for peon.
He was provisionally appointed, my lord, on 30th of August 94 as correspondence clerk. He was earlier appointed, my lord, as clerk, the PN, your lordship, on 23/8/74, joined on 27/8/74.
That is not disputed. Later on, his services were regularized in the post of peon. Thereafter, when he was promoted to the post of clerk,
He was appointed on the post of correspondence clerk, your lordship.
where is that order?
30/8/94. नहीं लगाया है, नहीं लगाया, हम भी नहीं लगाया, वो भी नहीं लगाया. नहीं, रिकॉर्ड पे वो नहीं है जो, ना तो रिट पिटिशन में है ना काउंटर में, बट इन एलपीए में ये
No,
सारा
you
डेट
produce the promotion order.
आई विल
Matter heard at length.
लिख लीजिए.
We find prima facie there is no case for condoning the 2 years delay and 191 days to stop. However, in order to ascertain factual aspect on the merit, factual aspects of the matter, it is necessary to peruse the order of promotion to the respondent
promotion
to the post of clerk. If he had been promoted to the clerk, then next question would be whether is he entitled to second ACP with reference to the service particulars or not. Perusal of the records, nowhere it is stated that on what date he was promoted to the post of clerk, and therefore appellant are hereby directed to furnish a copy of the promotion of the respondent to the post of clerk in order to ascertain as to whether is he entitled to second ACP benefit or not. List this matter after 10 days. It is made clear that no further time would be granted. You also take down the learned counsel for the petitioner, appellant, in order to overcome the delay. In order to overcome the delay issue, he cited Apex Court decision reported in AR 1961 SC 1704 Navratna Mall versus State of Rajasthan, para 9 and 10.